what Mr. Morgan has presented. So
Yes, sir.
that's what he indicated. So if it goes outside of what you have, make your objection, and I'll turn the machine on. I'll have it turned off. I'll put it that way. Come on in, ladies and gentlemen. Make yourself comfortable. Come on in, ladies and gentlemen. Make yourself comfortable. Thank you, Mayor. Thank you very much, as always, for your patience and your understanding. Come on in, ladies and gentlemen. Make yourself comfortable. Come on in, ladies and gentlemen. Make yourself comfortable. You can be seated in a seat, or you can sit in your favorite seat. Completely up to you. Thank you for your patience. Thank you for your understanding. Every now and then, we've got to take up some matters outside of your presence. Don't draw any emphasis from that one way or the other. Thank you. Lawyers and parties, you may be seated. Mr. Morgan, you may call your next witness.
Thank you. By stipulation, the state and the defense have agreed that the 3 clips that we intend to play to the jury this time are 3 clips, 3 audio-video recordings done by the Dunwoody Police Department Detective Andrew Thompson of Shane and Citron on January 21st, 2011 at the Dunwoody Police Department. This time, Your Honor, we would ask for permission to play these 3 clips.
All right, Mr. James.
Well, the state doesn't object to the, well, I believe Your Honor ruled that they were admissible. I don't recall stipulating to their admissibility.
I did rule that I was going to allow them to be played over state's objection.
Yes, sir.
All right. You may play those clips as you desire, Mr. Morgan.
Yes, Your Honor.
Well, how did the relationship seem to get unusually rocky during that period of time?
They were having a hard time. They were definitely having a hard time, but not necessarily different than anybody else who has, both parents have full-time jobs and trying to figure it all out.
Right. Now, she did end up deciding to hire a nanny, or they both decided to hire a nanny. Did things smooth out after that?
Yes. I caught up with.
All right, that's clip 1.
Yes, Your Honor.
All right, you may proceed to clip 2. As agreed, well, not straight, as indicated, you can play.
Is she the kind of person that... I'm trying to figure out how to word this correctly. That would bend her morals or her ethics to stay in the job?
No.
All right, that's clip 2. You may play clip 4.
Thank you, Judge.
You're welcome.
Bring that up out of the blue, or did you specifically ask her?
Oh, well, when she was telling me about Hemi, I asked her point blank if anything was going on with her. I asked her, and she said no. I mean, we've been friends for a long time. I would think that if something was going on, when I asked her that point blank, and I've asked her probably twice now, once at that meeting, at that lunch, and then I also asked her, I think it was like the night or two before he was arrested, I asked her again, because she showed me the email that he sent her while she was in Florida or something, the one with the song attached to it. She showed it to me. I'm like, Andrew, was anything going on between you guys? And she said, no. I've asked her twice. I would have thought she would have told me.
All right. Anything else on that issue, Mr. Morgan?
No, Your Honor.
All right. All right. The defense may call us next witness.
Your Honor, may reapproach.
Sure. Come on up, lawyers.
Jeff Hullinger with BJ Pack, and we are here taking some of your questions. We are really getting a lot of interesting thoughts and comments from this as we sort of jump in and out. How about the insurance issue in all of this? Has it been underplayed at all, do you think?
I think it was more central fact when there was the murder charge was there, because you recall originally this case was charged as part of a RICO or racketeering case, and the motive explained therein was this $2 million insurance policy. But this is more of a perjury trial, and the murder is not central to the elements of the offense that she's currently on trial for. So I don't think it's underplayed. It's kind of irrelevant.
You know, we have been talking about the trauma center and Atlanta Medical, why Rusty was taken to Atlanta Medical Center instead of Northside. And Matthew Jenkins off of Twitter says to me, Rusty probably needed higher care than level 2. Atlanta Medical Center is level 1, and level 1 is the highest. So that's our answer as to why he was taken there.
I guess my guess was correct.
It is. It's a very good guess. But you are an attorney as well as a member of the Georgia House, so you are a guy who doesn't guess. You just are in the know.
Well, I do know the different trauma centers,
Sure.
and Georgia probably needs more.
Yep.
And so I'm familiar with that.
Yeah, that has been certainly a point of contention among a lot of state legislators. But here we are. We are almost 10 minutes after 4 o'clock, and we have seen a lot of gatherings in front of the judge like this today. We've seen at least a half a dozen of them. We just saw some video clips from Shayna Citron with Dunwoody Police. So at issue here now is what? Where to proceed from here, or does it involve more of this sort of trial within a trial testimony that's coming off DVD and police interrogations?
I think it's the latter. Since I didn't see any live witnesses sitting outside, it may be replaying of certain clips of certain video evidence that has not been introduced into evidence. Those 3 clips, from what I could gather from listening, were helpful to the defense. It showed that, at least Ms. Sneiderman was consistent in her denial of having an affair, even to her friend. And her friend, Ms. Citron, did tell the police that back in January of 2011.
Here's sort of the football equivalent from the defense team as they are huddling before their next play, if we can make that sort of metaphor work. I'm not convinced we can, as they break huddle and now come back toward the judge again, trying to decide maybe an option that the judge has given them.
Yes, and they huddle to discuss what to do and what the proper approach is, and they're going back for further argument. And given the fact that they're not conferring with the defendant on these decisions, it may be purely evidentiary in nature, procedural, and not really substantive.
So the remainder of the day will be taped testimony, since we have not seen any defense attorneys that have been queued up outside the courtroom at this point. So the rest of it will probably be on DVD then.
That's correct. And given the late hour, I would be surprised if the defense would want to. And should Mrs. Sneiderman decide to testify, it would be unwise to start her testimony at this late in the juncture and then put her back on the stand tomorrow.
So when will Judge Adams ask Andrea Sneiderman if she will testify? He did that yesterday.
Right before the defense rests, and the judge will ask the defense lawyers how many more witnesses or how much longer are you going to take, and they would advise him, well, we're done. We have one more thing. We'd like to confer with the client about that, and so he would inquire because he wanted to get a good handle on when the jury should get the case.
Does she have to give him an answer today? Could she delay it for another day?
Not necessarily. I think the lawyers, as officers of the court, you should answer the question. So if the court asks outside the presence of the jury, counselor, how much longer do you have, or what is the decision of your client? Does she want to testify? To put it on the record, and also to gauge how much longer the trial might last. So you could give an estimate to the jurors that when they should expect to get the case.
Ruth Ellen off of Twitter asks us, it seems that Andrea Sneiderman has a lot of freedoms for being under arrest. Cell phone in court, does house arrest allow this? Well, the house arrest ended when the murder charges were dropped. It took about 72 hours for the ankle monitor to come off and for her to be a free woman again. But once those murder charges were dropped, she essentially is a free woman, and she can go about her way much as you and I can, correct?
Yes, and on top of that, remember, any kind of restrictions before trial is to assure 2 things. One is to make sure that the defendant doesn't commit any additional crimes while she is facing these charges, and number 2, that she's not a flight risk, or she's not going to run. So those things are the only restriction, and the purposes of which you grant bond and to things like that. So having email access or telephone, things like that, shouldn't occur. As a matter of fact, she should be able to continue working if, in fact, she's employed, and all other restrictions other than her being confined to her house should be not restricted.
Susie in Dunwoody is clearly believes in the innocence of Andrea Sneiderman, and she says to us, well, I'll tell you what, we'll get to that when we come back, but she makes a point here that is an interesting one, and it is worth talking about. Well, let's go into the courtroom right now.
Good afternoon again, ladies and gentlemen. Thank you very much for your patience and your understanding. The good news is this. We're going to give you an earlier recess today than normal. That's the good news. All right, and the other good news is we're going to reconvene tomorrow. Okay? And I appreciate your patience. Don't draw any conclusions one way or the other. I want you to continue to keep an open mind. I need you to be alert and attentive and listen to everything. And actually, you've been a great jury up to this point, and I really appreciate your high level of attentiveness. Let me give you these instructions. With the assistance of Deputy Garrett, we are going to allow you to depart for today. There's Deputy Garrett, there's a note. If you could go ahead and get in position, let the note go down and to my deputy. He will pass that up to me. And if there are any other notes before I give you these instructions, while he's doing it, because he's doing multitask, I want you to listen while I give you these instructions, because I'm still going to give you these instructions, no matter what this note is. Do not discuss the case or allow anyone to discuss the case with you. Once I release you for today, do not remain upon the floor. I want you to leave and go and come back fully refreshed tomorrow. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog about this case while it is ongoing. Do not go to any location that may have been made reference to. All the evidence will come to you in the form of sworn testimony from this witness stand and any physical evidence and evidence that's introduced during the course of the trial. You're more than welcome to bring something to snack in or eat with you for tomorrow's session. Do not consume any alcoholic beverages during our lunch breaks. Deputy Garrett will return to your iPhone, smartphones, iPads, and communication device, but do not text, email, or send any communication about this case while it's ongoing. As I've indicated several times, the lawyers and the parties cannot talk or interact with you, and we will be reconvening tomorrow morning. Just stay right there for a moment. Let me read the communication that has been sent to myself. All right, I have read the written communication. I fully understand what you have communicated with me. But we are still going to have to reconvene at 9 o'clock. And I understand. I know there are challenges, and I fully understand people have responsibilities outside of being a jury member. But at this point in time, I need you to honor your commitment that we made when we interacted weeks ago to be available during this time period. All right? I've been trying to end and start at a reasonable time so that sometimes matters that can be taken up before we get together, during that break in the middle, I call lunch break, and then in the evening, because now I'm leaving, and I understand there's challenges, and I don't need to know what the challenges are, but the commitment is I need you to be on time. And I need you to do everything possible, humanly possible, to be here so that you can fulfill your civic duty and responsibility in this case. All right? As I instructed earlier, do not discuss the case, allow anyone to discuss the case with you. The times are generated so that we can move through in an orderly fashion. And I fully understand life has its ups and downs and things happen. I can't control any of that. The only thing I can control is the start time. That's why we're going to start at 9 o'clock tomorrow morning. Okay? What I need you to do is do everything humanly possible to do what you need to do what I'm asking you to do. Do not discuss the case. Allow everyone to discuss the case with you. Do whatever you need to do. You leave a few minutes early today. If you can't do it now, that's okay. But I need your body and your mind and your spirit physically in this building ready to go at 9 o'clock tomorrow morning. I need all of them. So the best you can, meet your obligation as best as you can. Thank you for your open-mindedness. Thank you for your willingness to obey my instructions. And I will see each and every one of you each and every one of you tomorrow morning at 9:00 a.m. That's it. Follow the instructions of Deputy Garrett. Lawyers remain. And you can leave your notepads there in the jury room, turn them face down. Nobody's going to look at your notes but you. We got plenty of pads for you. Notepads if you need more. And I think I gave you a new pencil sharpener at your request, so you sent out a note. I'm trying to deal with all those issues too. All right, lawyers and parties, have a seat for a moment, please. Yes, lawyers, you can approach before we go on the record.
I was just going to put
Yeah, I am. I'm going to let you
on the record.
Yeah, I am. I'm going to let you do that too.
Okay.
Just come up for one quick second.
Oh, okay.
If you don't mind.
And something else. Yes, sir.
Jury is done for the day. The attorneys are not done. DJ Pak, where does it go now with both sides here?
Well, there was no discussion about any additional witnesses, which may include the defendant. So they have some legal discussions to talk about. And if she doesn't testify again, the prosecution has a chance to present rebuttal evidence. If they do, I don't anticipate that being very long, because I think the defenses were in fact anticipated. And then after that, there's argument on whether or not there should be a directed verdict. And after that, it's closing arguments.
So the very earliest, maybe the jury gets this case on Friday.
Yes, I think that's probably the earliest time they could get it.
When we were at
Back
the
to Judge
bench
Adams.
previously, I had indicated to you that our next witness was going to be Chief Grogan of the Dunwoody Police Department for the purpose of playing a tape that was surreptitiously made of the notification of Mrs. Sneiderman back on January 4th of 2011 that Hemi Newman had been arrested in the murder of her husband. We anticipate that on that particular tape, her initial response would have been an audible and to some extent horrifying scream when she found that particular information out, and then her response would have been, as a practical matter, she was inconsolable and it was incomprehensible to her that that had in fact happened.
Yes, sir.
She is charged in several counts of the indictment. She is charged in at least 2 counts of the indictment. She is charged in count 2 of the indictment, or what is currently count 2 of the indictment, with concealing her knowledge of Hemi Newman's culpability in the murder of Rusty Sneiderman. She is charged in count 4 of the indictment, or actually no, it would be count, I guess actually that would be the current count 1 of the indictment. I'm looking at the old indictment. Okay. What would be count 3 of the current indictment, that she never suspected that Hemi Newman was involved in the murder of Russell Sneiderman prior to December 28th, 2010. She is charged in count 7 of the indictment with committing perjury when she allegedly testified that she had no knowledge that Russell Sneiderman had been shot at the time she spoke to Donald Sneiderman prior to her arrival at Dunwoody Prep. And she is charged with making a false statement in count 5 of the current indictment when she allegedly told Lieutenant Barnes and Deputy Chief Sides in the interview of January 5th that she did not know what had happened to Russell Sneiderman at the time she arrived in Dunwoody Prep, when in fact she knew that Russell Sneiderman had been shot prior to arrival at Dunwoody Prep. We believe that the tape in question would be extraordinarily relevant and germane to each of those issues. We believe that the emotional response and the ungodly sound that she uttered when she first found out that Hemi Newman had in fact been arrested for the death of her husband would corroborate the fact that she was unaware that he had in fact committed the offense, and would go to specifically defeat those counts that I have specifically made reference to. It is my understanding that the state has objected on the basis that this would have been a self-serving declaration and is hearsay, and as such is not admissible. First off, she was not charged with a crime at the time when this statement was made, when the original sound and then whatever subsequent statement she made. Secondly, she was not aware of the fact that she was being taped. Third, absent some sort of knowledge that she would subsequently be accused of this particular kind of offense and accused of having some sort of advanced knowledge that Hemi Newman would have committed this particular crime, or absent knowledge that she would be accused at some point of lying under oath for having said that she did not suspect Hemi Newman had committed this crime prior to December 28th, there would be nothing necessarily self-serving about her statements in question. It is simply her honest emotional response to being provided with information by the police. The District Attorney's Office has introduced through the Dunwoody Police Department 3 different statements from Mrs. Sneiderman, that of November the 18th, that of November the 24th, and that of January the 5th. This is one more in a series of those statements that was, quite frankly, obtained from Mrs. Sneiderman, although at no time was it a traditional statement in the sense that there is calm, rational questioning and calm, rational answers. There are questions and answers posed, but the, quite frankly, almost hysterical nature of her response and the discombobulated nature of her response is not suggestive of any sort of trick or artifice on her part. She is just responding to information provided by the Dunwoody Police. As such, we do not believe it is in any way, shape, or form a self-serving statement. We believe it was gathered by the Dunwoody Police Department during the course of their investigation. And again, since there was no specific charge pending against her, and since she had no way of knowing that she would be charged with any particular offense, it cannot be, under those circumstances, a self-serving statement. So therefore, we have asked this court to admit that statement into evidence. It is my understanding, based on the court's ruling at the bench, that you are not going to allow that, and we respectfully object to that ruling for the record, Your Honor.
Yes, sir. Mr. James?
Your Honor, counsel is right in part and wrong in part. He is right that if said evidence were admissible, based on the state's indictment, it would be relevant. If it were admissible. However, evidence has to be relevant and admissible. And in this case, the mere fact that it's relevant makes it inadmissible. What I mean by that is it's relevant because it is an exculpatory statement, all right? And the rules of evidence do not allow non-self-inculpatory or exculpatory statements from a defendant that has not testified. What I'll do is I'll cite the federal cases, Your Honor, and as Your Honor knows, the new rules that were passed, they have stated in their body that we are to lean on 11th Circuit cases, and there's a 9th Circuit case, and there's also an 11th Circuit case that cites the 9th Circuit case. It says, for the following reasons, we affirm the exclusion of Ortega's non-self-inculpatory statements or exculpatory statements. And I'll give Your Honor the cite. It is United States of America versus Jose, J-O-S-E, Roman, R-O-M-A-N, Ortega, O-R-T-E-G-A. And the case site for that is 203 Federal 3rd, 675. It is a 2000, it is a case from the year 2000, Your Honor. This is a 9th Circuit case. In a second, I'll cite the local case, which is the 11th Circuit case. It says, for the following reasons, we affirm the exclusion of Ortega's non-self-inculpatory statements. First, Ortega's non-self-inculpatory statements are inadmissible even if they were made contemporaneously with other self-inculpatory statements. The self-inculpatory statements, when offered by the government, are admissions by a party opponent and therefore not hearsay. But the non-self-inculpatory statement are inadmissible hearsay. And then it cites to another case. It says finding that the fact that a person is making a broadly self-inculpatory confession does not make more credible the confession's non-self-inculpatory parts, which are hearsay. Then it gets to the relevant part of the opinion, and it says if the district court were to have ruled in his favor, Ortega would have been able to place his exculpatory statements before the jury without subjecting himself to cross-examination, precisely what the hearsay rule forbids. Thus, the district court did not abuse its discretion when it limited Ortega's ability to elicit his exculpatory hearsay statements on cross-examination. Now, the case that cites to Ortega is an 11th Circuit case, Your Honor, and it is Christopher Green versus Walter McNeil. It is a 2010 11th Circuit case, and the cite to that is, I have the Lexus site, is 2010 U.S. District Lexus 103312. And again, it is a 2010 case. And it says self-serving statements are not exempted from the hearsay rule or any other exemption or exception, and thus inadmissible hearsay. Cites United States versus Ortega. It further states, Your Honor, that if exculpatory statements were admitted at trial, a defendant would be able to place his exculpatory statements before the jury without subjecting himself to cross-examination. Again, quoting Ortega, what the hearsay rule explicitly or precisely forbids. It says further, and it even makes this distinction, even if portions of the written statements had been admitted during the detective's testimony, possibly implicating the rule of completeness, exclusion of Green's exculpatory statements would have been proper because the statement still would have constituted inadmissible hearsay. I disagree with counsel. I categorically disagree with counsel's characterization of this audio tape. I have listened to it, and when Chief Grogan informs the defendant that Mr. Newman was the person that murdered her husband, she doesn't yell out screech. She says, "Oh no," and then says "Oh no, Hemi," and then she calls his name multiple times, and then she starts asking questions like, "Are you sure?" and things of that nature. So there is no high-pitched screech that's inaudible. She yells. She's emotional, but it's very much words that are being used, and quite frankly, throughout the entire tape, she cries, asks questions, makes statements, cries, asks questions, makes statements, and makes declarations, asks questions. I think she says something to the effect of, "Is it due to what I told you tomorrow?" Which is what is it due to what I told you earlier today? Which is what I suspect perhaps counsel wants to get it in for. He says no. They go through this whole conversation. Yes, she is emotional, but she is very much making statements and declarations. And based on current case law, current established case law, and furthermore, based on the case law under old Georgia law, it would still be inadmissible. I didn't pull old Georgia cases, but this was a rule that was in place even before the new rules, Judge.
All right, Mr. Clegg, anything else for the record?
The only other thing I would note for the record, Your Honor, is Mr. James and I disagree as to what an exculpatory statement is. If somebody says, "Did you rob this bank?" and the suspect says, "No, I did not," and that is the entirety of the interview, then that is obviously an exculpatory, self-serving statement. We submit that this is not a self-serving exculpatory statement under the circumstances of the nature of this interview, because she wasn't charged with the crime. There was no indication she was going to be charged with the crime, and she had no anticipation of being charged with the crime. Absent that, I don't see, when she isn't actually confronted about her admission or isn't asked whether or not she has had any involvement in the particular crime, but is simply asking questions and being very upset and wanting to know how it is that Hemi Newman came to be arrested, I don't believe that's self-serving nor exculpatory. That is simply a fact of how she was at the time that she was conveyed this information. So I believe that the state is incorrect in saying this is self-serving, and I have nothing further, Your Honor.
All right, Mr. James, anything else for the record?
Your Honor, the only thing that I would state is I would correct Mr. Clegg. I said non-inculpatory and exculpatory. Ortega says non-inculpatory. The other case that I cited, Green, says exculpatory, but they use both phrases in the different cases. And the other thing that I would state is, if it's not exculpatory, then why does he want to use it? The mere fact that it's relevant means that he wants to use it to exculpate his client based on her actions and the questions that she was asking. So I think that's well, I'll leave it at that.
All right. Anything else?
The only other thing
That's fine. Go ahead.
Yeah.
I've sent the jury home for the night.
Yes, sir. There is her emotional tone and the nature of the actual communication being uttered by Mrs. Sneiderman speaks volumes as to the issue, leaving aside the actual specifics of what was said as to those issues that she is charged with in the indictment. Specifically, did she have knowledge that Hemi Newman committed this offense or was going to commit this offense before November the 18th, and did she suspect him before December the 28th? So even leaving aside what she said, which I do not believe was self-serving nor exculpatory, her nature and the manner in which she was communicating tends to refute the allegations in the state's indictment. So as such, it is relevant without necessarily being self-serving.
All right. Mr. James, anything else for the record?
No, sir.
All right. As I indicated, I will sustain the objection. All right. Anything else at this point in time on that issue? Yes, I'm sorry.
No, sir.
Mr. Morgan, yes, sir.
We just have something to put on the record as well, Judge, if you may.
Oh, sure. Yeah, let's go ahead and do your...
Can I just finish up?
I'm sorry. I thought you were finished. I didn't mean to...
No, I'm sorry. I just wanted to note that I do not have, I don't believe, a burned copy of Grogan's notification of Mrs. Sneiderman to put into the record at this time, but we will do so tomorrow morning.
All right. Thank you,
sir.
Yes, Mr. Morgan.
Thank you, Judge. I believe it was this afternoon, Your Honor, that the defense attempted to call Sherry Easter, E-A-S-T-E-R.
Yes. I didn't know what you were... I was trying to tell him, let this man in. I don't know who he is, but if he wants to come in, let him come in. Go ahead.
Thank you, Judge. If Ms. Easter had been allowed to testify, I will proffer the following. Ms. Easter was an employee at General Electric for 28 years. The entire time in the Atlanta office, she started out in a similar position or rank as Ms. Sneiderman and worked her way up through GE until her retirement when she was 28 years old. She would have testified that it was not unusual and very common for supervisors and their subordinates to travel together, whether they're male, female, male, male, female, female. She will also testify that in her own personal experience, as well as her observations, particularly here at the General Electric office in Atlanta. Let me preface it by saying that this prosecution introduced through testimony, I believe her name was Goff, Kathleen Goff, that there is a sexual harassment policy in General Electric, and that sexual harassment policy has been introduced and is evidence before this jury, and that employees, particularly female employees, if they're victims of sexual harassment, certainly have an avenue to report. It is the state's contention that...
You mean the defense?
It's the state's contention
Oh, I'm sorry.
that this was an affair and not a stalking or a balls hitting up on a subordinate, and that if it was anything other than an affair or a romantic relationship, then Mrs. Sneiderman would report it. Ms. Easter would have contradicted that in that her own personal experience that she had been subjected to sexual harassment at the General Electric office here in Atlanta and by none other than a supervisor in human resources after consulting with other women, and she had just started there, that she was advised not to report, that if she so reported that it would certainly be detrimental to her job and to her promotion, that her observation during her 28 years at General Electric that women who did report were subjected to intimidation and possible that they were not allowed to progress as others. And it's just something that, unfortunately, women have to put up with.
All right, who's responding on behalf of the state?
Oh, well, Your Honor, I believe that was my witness. And while the state does not disagree with the fact that it is not uncommon for male and female coworkers to travel together, and while we don't disagree with the fact that GE does in fact have a policy against sexual harassment, Ms. Easter's testimony was, Your Honor, that she's never met the defendant in this case. I believe she also testified that she is retired from GE, so we have no idea as to when she would have had her own personal experience with a sexual harassment claim and what her own personal experience was as a result of her reporting the sexual harassment. Nevertheless, Your Honor, whatever her personal experience was and whenever it was, the state's position is it is irrelevant and it is not germane to the issue in this case. And that was the basis and the reason for our objection, and we still maintain that it will be Ms. Easter's testimony was completely irrelevant to the facts and issues in this case.
All right, Mr. Morgan, anything else for the record?
Nothing for the record, Judge, other than had we gone forward, we would have shown that that's correct. Ms. Easter does not know Mrs. Sneiderman. She does not know anyone on the defense team, that she came forward only after watching this on the news and wanted the defense team to know about what went on at GE.
Okay, yes. Anything else from Ms. Hill?
Nothing further from the state.
All right. And I believe, went straight there. All right. Record's made. I'll leave it at that. Anything else?
Yeah, I do have a copy of the actual notification that was made of Mrs. Sneiderman by Chief Grogan back.
Oh, you do have it now?
Yes.
Oh, wonderful.
I just need to know the number to mark it accordingly and introduce it for purposes of the record.
Yes, sir.
47?
47?
That would be defendant's exhibit number 47. And again, I am tendering this only for the purposes of the record. Your
I
Honor.
understand. So noted. Ms. Carpenter will accept that for the purpose of the record. Anything else?
Nothing from the state, Your Honor.
No, sir.
All right. And we will be in a position to continue with those witnesses tomorrow, Mr. Petrie, as planned? All right. And I believe you have the next witness, Mr. Petrie?
Yes, sir.
And then we'll deal with any other issues after that. Thank you, Mr. Petrie. All right, lawyers, we completed making the record for the evening. What I had mentioned, and if the lawyer, and people can stay if they wish, to have a, what I call a preliminary charge conference on those general things that we can talk about now, and obviously we will have a final charge conference at the appropriate time. And the reason I want to do that this evening, if the parties are still available, so that if and when the case concludes, we can have the final at that point in time, and obviously we'll always have the charge conference outside the presence of the jury, and the charge conference must precede any closing arguments that are presented both by the state and the defense. Is the state in a position, this afternoon, to do a preliminary charge conference?
Yes, Your Honor.
Is the defense in a position? Who's going to handle that?
I believe Mr. Petrie will be primarily handling that, Judge.
The paralegal apparently couldn't find the state's request in my office, but so I might need to look over somebody's shoulder.
Well, we can. I mean, I can locate the clerk, and they can bring up what was
I think
found.
Ms. Cross said she's got a copy.
Okay.
I've got.
I have one that a copy can be made for you.
That's great.
And I can have someone make a copy, if you wish. Did you? That's fine.
I thought you should.
All right. Actually, it won't be. What I'm going to do, I'm going to let you have access to a copy.
Perfect.
All right. You can. I'm just going to sit right here.
Your Honor, would you entertain letting those of us in the courtroom with jackets on take them off for a few minutes while we do?
Lord, the